Hello, and thanks for joining us today. My name is Jerard Ross. I'm one of the medical legal advisors from the MDU. I'm joined by my colleagues from other departments. I've got Helen Churchill here, one of our solicitors, and Ed Nandasoma, one of the other medical legal advisors. Ed's going to be busy working in the background to field your questions about this webinar. Today, we're going to be talking about understanding coroner's investigations. Being asked to provide a report to the coroner and to attend a coroner's court to give evidence can be, and indeed is, quite a daunting task. Like many situations, if you don't know how to do it, it can be quite anxiety-provoking. So this presentation, we hope, will give you an overview of all the process involved in inquests and how you can manage them. But don't forget that as an MDU member, you've access to personal advice from a medical legal advisor, and all of us have detailed knowledge of the processes involved. As with everything, preparation is the key to success, and being aware of what to expect can reduce the anxiety from engaging with these processes. So there's 3 of us involved in doing this. Feel free to ask questions via the app, and my colleague Dr. Nandasoma is going to be beavering away, answering and helping us field those questions into the arena for all of us to see. He's going to interject at times with particular relevant points during the webinar. So what I'm going to do first of all is I'm going to get rid of the pictures of all of us, and at the moment you probably don't need to see those. And we'll move on to the first slide. So we thought we'd start with a poll. And you have the option to answer this for us, to just get an idea of what your experience has been of being involved in inquests and those processes. So the first question is, who's written a report for the coroner? So we're just collating all those answers first of all. That's good. We've got about 3/4 of the audience have responded so far. Thank you very much. Keep it coming. Brilliant. I think we could probably share those results now. We've got 57% of the audience have written a report for the coroner and 43% haven't. So let's move on to the second question. Who has attended an inquest? Great, that's really helpful. So we've got a lot of answers there. 36% of you have attended inquests, and 64% have not been in an inquest before. So we asked our members these questions and related questions as well. Of our members, 26% had never had to provide a report to the coroner, but 18% of the members had to do it more than 5 times. When we asked them about attending a coroner's inquest, around about half of the people who responded had never had to attend an inquest, whereas 3% of the doctors who responded had been more than 5 times. We then went on to ask about whether people would understand what they had to put into a report for the coroner if they were asked to provide one. About 1/4 of the doctors felt very confident, 60% thought they might need some help, and 14% really had no idea what they'd like to put in. And then we came to actually being called to an inquest, if people knew what they might expect. 18% felt they felt prepared and knew what to expect. 47%, about half the audience, had an idea of what they might expect, but well over a third didn't have any knowledge about what they might face when attending an inquest. So, with that in mind, this is what I'll be covering today. I'll be covering the role of the coroner, which deaths should be notified to the coroner, writing a report for the coroner, appearing at an inquest, and at that point I'll be getting some help from Helen, and inquests and the GMC and the relationship between those two bodies. So, let's think about a scenario. I can't write a scenario that's going to be equally applicable to all of you, but I think there are some important points which can be applied to anybody who has got to write a report or who becomes involved with the coroner. I'll let you read this one through. So first of all, coroners are contacted about lots of death, and not all of those contacts are deaths that require investigation. So the first thing they have to do is decide whether or not a death lies within their jurisdiction. And that means that the body is in the right place, so it's within their geographical area, and that certain criteria are met. Those criteria are that the coroner has reason to suspect that the deceased has died a violent or unnatural death, or the cause of death is unknown, or the deceased died whilst in custody or otherwise in state detention. And it's that combination of location and suspicion that defines the coroner's right to investigate. And that was lifted directly from the Coroners and Justice Act 2009, which was enacted in 2013. Essentially, in those circumstances, the coroner must establish the facts around the individual's death. Those facts being the who, the how, the when, and the where. Unlike other types of courts, an inquest is not an adversarial process. It's instead an inquisitorial one where the coroner asks questions of the various witnesses arraigned before them so that they might be able to answer those 4 questions that I gave you. Importantly, the coroner is able to refer deaths to the police for a criminal investigation should it appear appropriate, and in answering the 4 questions I've referred to, the coroner is specifically prohibited from returning a conclusion which attributes a criminal or civil liability on anyone. So I'm just having a small technical problem with the slides. Here we are. We're going to talk very briefly about the Coroners and Justice Act 2009, because that act had a number of different impacts. For instance, prior to 2013, it was necessary for coroners to open an inquest to investigate a death. But now, as a result of this act, they only have to conduct an investigation. And from the information gleaned from that, they then decide if an inquest is necessary. So, for example, it might be that a post-mortem done as part of a preliminary inquiry reveals a certifiable cause of death, which means that the death is no longer in the coroner's jurisdiction. For instance, that the patient's died of natural causes. So not every investigation will lead to an inquest. To investigate a death, be that a preliminary investigation or a formal inquest, coroners need information, and that information comes from various sources, including families, the police, other doctors, and doctors may be asked for a statement. may be asked to attend an inquest, or they may be asked to provide any other document which the coroner thinks will be of assistance. Alternatively, doctors might be served with a notice under Schedule 5 requiring a statement, and failure to comply with the latter is an offence punishable by a fine. But as you know, doctors are under professional duty to comply with a request from a coroner for information, and that comes from paragraph 135 of confidentiality, which says that you must disclose relevant information about a patient who has died to help a coroner. The GMC are also clear that you have to cooperate with any timescales imposed upon you by the coroner, and that comes from paragraph 5 of acting as a witness in legal proceedings, again from the GMC from 2013. So don't ignore that request from the coroner, as failure to comply again might result in a fine or even a complaint to the GMC. The 2009 Act also introduced into primary legislation the coroner's duty to make reports. Those reports might be to a person, to an organisation, to a local authority, to a government department or agency where the coroner believes that action should be taken to prevent future deaths. A copy of the Prevention of Future Deaths report is sent to all the interested parties, for instance, the deceased's family, and it actually is made available for anyone to read on the Chief Coroner's website. Importantly, though, for health and social care providers, a copy of the PFD is also sent to the CQC, and they may follow up on any concerns raised, for instance, by an unannounced inspection. So, how does a coroner hear about deaths? Well, as you can see on the slide, there are a number of sources of information from the coroner, but until recently, only the registrar was obliged to refer deaths to the coroner. As of October of last year, doctors became obliged to report certain deaths, and I'll come on to that in a minute. The police may refer a death to the coroner, and medical referees, those are doctors who visit crematoria to review death documentation and give written consent for cremation, can also refer deaths to the coroner, as can medical examiners. Medical examiners are a new role that are becoming more common in acute trusts in England and local health boards in Wales, and they focus on issues around the certification of deaths that occur within their own organisation. And of course, families of deceased patients may report a death too. And we often see that as an extension of or an addition to the complaints process, with the family complaint ending up in the coroner's bundle of documents. So what about the numbers? Well, this slide comes from the 2019 government statistics. So at 530,000 or 531,000 nearly deaths in England and Wales, with about 40% of those deaths being reported to the coroner. Of those deaths that are reported, about 40% will go on to have a coronial post-mortem, and about 30,000 or 14% of the deaths reported going on to have an inquest. So you can see that from the figures that roughly 5 to 6% of deaths in England and Wales last year resulted in an inquest. As I mentioned a minute ago, doctors are now obliged to report certain deaths to the coroner, and that duty, which is from the Notification of Deaths regulations, applies to regardless how much time has passed since the death, and the duty applies unless a doctor reasonably believes it's already been reported by another doctor. Reports from the family to the coroner do not remove the obligation placed on doctors. There is guidance about this on our website, and there's lots of information there as well about coroner's processes, so do have a look if you're concerned about that. So, from Regulation 3 of the Notification of Deaths Regulations 2019, we have this list. These are deaths that have to be referred. So unnatural deaths secondary to poisoning, including by an otherwise benign substance, exposure to or contact with a toxic substance, the use of a medicinal product, a controlled drug or a psychoactive substance, violence, trauma or injury, self-harm, neglect, which includes self-neglect, a person dying undergoing treatment or procedure of a medical or similar nature, an injury or disease attributable to employment held during the person's lifetime, or the doctor suspects the person's death was unnatural, but it doesn't fall within any of those circumstances listed. So quite a broad ambit. And coming back to our case, the patient's falling in the hospital and sustaining a subdural and dying from that, that would fall into something needing to be reported because of trauma or injury. There are some other circumstances which require reporting too. So the registered medical practitioner would have to refer it if, despite taking reasonable steps to determine the cause of death, they don't know. The cause of death is unknown. If they suspect that the person died whilst in custody, and I said, or otherwise in state detention, and that's quite a broad definition. It includes things like deaths in prison, but also police cells, immigration holding centres whilst detained under the Mental Health Act, even on home leave or on a community treatment order, and might include voluntary patients. One exception, though, is since the Police and Crime Act of 2017, it doesn't include people detained under a deprivation of liberties safeguarding order. There are some broader issues which also might impact on the coroner's decision to investigate. These aren't regulations, but these are things that may weigh on the coroner's decision making. So concerns or complaints by a nearest relative about care, possible fault or neglect by medical staff, equipment failure, incidents that are going to be subject to adverse event review, deaths raising issues of public safety, and any death which might cause public anxiety. So doctors may be involved with the coroner because they have to refer a death or provide a report to the coroner. Doctors may also be involved as a witness of fact, which we're going to come on to, and perhaps less frequently as being an expert witness in the court, so helping explain to the coroner what should have or could have happened. To that list, I think we can add having to respond to a prevention of future deaths report. So if you were in a senior position in an organisation, if you're the managing partner of a GP partnership, for instance, or if you're the medical director of a trust, you may have to respond to the concerns or issues raised within a PFD report. So some of our learning points here. As I think we've pointed out, many doctors' experiences of coroners' processes is relatively limited. We now know a little bit about how deaths fall into a coroner's jurisdiction. We've covered that there's a new duty requiring doctors to notify deaths to the coroner, which wasn't present before the end of last year. And we're now aware, I think, of the GMC obligations to cooperate. So unless there's any burning questions from that first section, we can move on to writing a report for the coroner. So going back to the scenario that we've mentioned at the start, the doctor is asking for help as trust legal want to him to produce a report to pass on to the coroner. I'll let you read through the rest of that. So as often happens, the doctors read through the notes and realised there are some things that they may have wished to put in retrospect. Let's have a look at an exemplar draft report. Now, this is an example of what some people might write for their first draft. It is exaggerated to some extent for effect, but contains a few of the common errors that we see. When did this incident occur? At what time? Who is this person, Dr. D, writing the report? What are their qualifications? The coroner may not be medically qualified, so they may not know what an SHO is. They certainly may not know what a query NOF is, neck of femur fracture obviously, but they may not know that. The examination hasn't been detailed, and it's not really couched in terms that allows easy communication of facts. So in this circumstance, what I mean is they haven't really classified the patient's level of consciousness. They haven't discussed medication the patient was on, or if there's anything relevant in the patient's past medical history. So let's have a look at the second draft, have a read through that. So the doctor has clarified quite a lot of important points in that, a lot more detail in there. The doctor's gone on to mention the relevant medications the patient was on. He's detailed the examination that he's undertaken, and he's explained what he means by that. So this was a reference to the Glasgow Coma Scale, clearly a method of describing level of consciousness. The doctor's mentioned what his impression of the situation was, and he's gone on to note that although he's not noted it in the record, he did ask the nurses to do regular neurological observations. And he's made it clear that he wasn't asked to see the patient again. Where you're asked to include information about assessments others have made, it's important to make sure you're reflecting what's in the notes, and it's important also not to be critical of any other people that have been involved in the patient's care. One of the advantages of having a really clear report is that it makes it less likely that you're going to be called to give evidence, particularly if your evidence is not thought to be contentious. So if you can write a good report, you may be able to avoid being called to the inquest at all. They just read your report into evidence. So what does a good report look like? Well, Helen may have some comments to make on this as well, but I think that a good report is going to include your full name, your qualifications, your role at the time, the full name and detail of the deceased, summary of the past medical history and the prescriptions, recent illnesses and events leading to death, and a chronological record of your role in the clinical sequence of events. The coroner will need to see the patient's notes as well, but you shouldn't just send the medical records to the coroner rather than a report. Your job is really to interpret those medical records for the coroner, because as I said before, unlike years gone by, most coroners these days are not doctors. It's important that you write in plain English without medical jargon. So write as if you're writing for a layperson, like a lawyer, not another doctor. And do bear in mind that your report may well be shared with other people. So the family may well read what you've written. Be clear about who did what, and make sure you include the names of colleagues. Be clear about how you know the facts, whether it's in the records, whether you recall doing it specifically, or whether it's your usual practice, as in, I don't recall doing this, but it would be my normal practice to do X. Keep your report factual and stay within the bounds of your knowledge. So in terms of learning points, again, we know that the coroner may ask for reports from many of the people involved in the patient's care. check the notes before writing and submitting your response. If the case has been discussed at an SI meeting, then you may wish to say something about that in the report, because that, I think, tells the coroner that the organisation has thought about the issues that are being raised. Consider getting some help from us before submitting your report. It's often helpful to have another pair of eyes cast on what you're writing. And as I've said, a good report may result in you not being called as a witness and your evidence just being read in. Helen, do you have anything you want to add to that?
I fully endorse that which you've said. I particularly stress, as I sit here as a solicitor, not a doctor, that writing in plain English is really appreciated by the coroner and indeed all who read the report. It's certainly appropriate and potentially a good way to reference what you've written in the notes. If you have put shorthand in the notes, as would be common practice, state that and then include, and by that I mean, and then the coroner is able to look at the notes and look at your statement and almost cross-reference it, and that certainly makes it clear. And the suggestion that a good report may result in you not being called as a witness is absolutely correct. Put simply, if a coroner reads a statement and doesn't at that point have any obvious questions to it, nothing springs to mind, there are no clear gaps in it, it reads well and the coroner understands that doctor's involvement, then other than any other party wishing to question that witness, the coroner may simply take it as read, and that may require you not to attend the inquest, which is obviously in everybody's interest.
On that, as an extension of this particular slide here, and I haven't put it on the slide, for the GPs in the audience, often as a GP you're giving an overview report of a patient's contacts with the practice. So what I have seen on a number of occasions is doctors, I wouldn't say cutting and pasting, that's perhaps not fair, but taking large chunks from the record and just putting it into the report. And sometimes medical records are written in such a way that it's really quite hard for somebody to understand if they aren't a doctor. So that, I think that just emphasizes that. But what I was going to say about GPs doing overview reports is that if you haven't been involved in the care but you've been tasked with writing something for the coroner, it's always appropriate, I think, to double check with your colleagues that what you've written about their consultations is accurate.
Yeah, I'd entirely agree there, and simply dealing with it in the notes. If perhaps that colleague isn't available for whatever reason, you could extract that relevant entry in the notes and say, and I've read the notes and I can see the following entry is made. And if it's appropriate and you're comfortable interpreting that, for example, translating any medical shorthand for the purposes of the coroner's full understanding, then that's entirely appropriate. And of course, if in doubt, seek assistance from the MDU.
And it's Ed here. I've got a question that's come up, but I think it sort of relates to what we've been talking about, which is, can you resend a coroner's report that you've sent if you think you can add more detail, or will the coroner contact you if they require further information? Have you either got any comments on that?
Helen, do you want to take that one?
Yes. In short, you are obliged to assist the coroner with any and all things that would assist their inquiry. So if further information comes to light, certainly do provide that. I think what better practice would be, rather than sending an edited version of that which you've already sent, sending a supplementary report. So introing it as further to the letter I provided on X date, I've now obtained this information which may assist, and then set out that information. So it's clear that it's to be read in addition to that which you already provided.
Okay, well, thanks for that, Helen. That's good. Let's move on to the scenario again, which was our rotating junior doctor. I recognise this may not apply to everybody. So our doctor finalises a report and submits it to the trust, and then rotates on to a different training post. Several months later, he's told that he has to attend the inquest. There's a bit of a gap there between the patient, the member being involved in the patient's care and being asked to attend an inquest. And at that point, the doctor attends a meeting with the trust solicitor and finds out that there's actually been a root cause analysis done already. And actually, the root cause analysis was critical of him and of the nursing staff. And in my experience, I'm sure Ed and Helen will back me up on this. It's actually not that unusual for trusts to go ahead and investigate incidents that have occurred, because they're under time pressure to comply with significant incident review processes. But not to perhaps involve staff that have moved on to other posts. And that might be the same in general practice, that a GPST is in the practice at one point, is involved in care, and then is not involved in the significant incident discussion afterwards that takes place after a death. In this instance, the trust solicitor suggests to the member that he speaks to his MDO, or his medical defence organisation, about getting support. And the member contacts the MDU and asks whether he needs legal representation at the inquest. Now, we'll come on to this in more detail, perhaps not immediately. I'm just going to go back to that before that, I jump forward to that, to say that the trust solicitors are instructed to by the trust to look after the trust's interests, and they will usually represent employees of the trust as well, as long as the interests of the employee and the interests of the trust align. But every now and again, the interests of the trust and the interests of the employee do not align, because they don't agree on facts, or because the employer, for instance, has concerns about what that employee did. And in that circumstance, we might be contacted by the member, and we might discuss whether or not they need their own legal representation at the inquest. But Helen's going to talk more about legal representation in a few minutes. So the learning points from that really are, when you submit a report and you know you're going to be moving on, ask to be updated about any contact from the coroner. Explain what leave you might have. If there's going to be an investigation, ask to be updated about the case, and make sure they've got your best contact details. If you're told that you have to attend an inquest, don't panic, as I did there, as my slides jumped on by themselves. Get some advice and clarify your role at the inquest and whether the trust is supportive. Ed, have there been any questions that we need to address at this point, or should we move on to?
Just a couple of things in relation to this. We've had one comment that sort of says, look, that they faced a very similar scenario to the subdural scenario that you're sort of putting out, and the doctors commented that they were called to the inquest because they wrote the most accurate report. And they wanted to know whether we had any comment on that. But my observations would generally be that the coroner pretty much knows who can give the most relevant evidence and who had the most direct contact with the patient, and so they don't tend to just look for the person who's written the fullest report. But any sort of observations you or Helen would have, I think, would be interesting.
Jerard, perhaps I could answer this. It does sometimes happen that the coroner identifies from initial statements who might be the best person to call. Often GPs find themselves in that role. They've had overview of care for a prolonged period, and that can result in a coroner using them as a bit of a crutch of sorts to feed through the investigation across the chronology of the medical records. More detail where required, it is always best to assist the coroner. That is your obligation as a doctor in relation to an inquest. The difficulty does sometimes arise as to how do you know what's relevant, particularly if the request being made of you is many months after the fact. But I think, again, if in doubt, is seeking further advice on the specific pattern of that inquiry.
Okay. Ed, was there?
Yeah, on a similar point, relating to reports, we've got a comment for a doctor who works in a mental health team, where that often it's a very multidisciplinary approach. There may have been lots of other practitioners who've seen the patient after the clinician's contact, and they say, look, how much information about those subsequent contacts should they provide to the court?
Okay, well, I think that's going to be dependent on the situation in which you find yourself. Your role is really to interpret the medical records for the coroner. So I think that if there are important contacts that are in the records that you have access to, you can point out the fact that they occurred to the coroner, and then it's up, I think, to the coroner as to whether they want to approach those people for statements. I can think of numerous times when a GP's been involved in a patient with psychiatric problems, gone to commit suicide, and they've perhaps made a referral into the mental health team or to counselling or whatever, and that there's been some contact with those services. It wouldn't be unusual for the doctor to point out the fact that, yes, I saw the patient on this day, but there were a number of other people involved thereafter. Helen?
Yeah, I'd entirely agree. Signposting the coroner to a better source of relevant material, if you are in that sort of gatekeeper role, is a good approach to take, and let the coroner then determine, having read your initial response, who else is involved that might be of relevance, and whether or not the coroner then needs to approach them for their own statement detailing their involvement. That's often an approach I take when my member has an initial involvement, often again with the GP or the lead CMHT professional, and directing them, yes, we treated the patient through this period, but their care was then under the management of, and then signposting the coroner to that extra other source of information.
Yeah. Okay, if there's no other burning questions we need to address, I think we can probably move on to the next part. I'm going to stop sharing my camera, and I'm going to move on to the coroner's court. And Helen, I think, is going to take this part. Let me just move the slide on. Helen, just you let me know when you want me to move on.
Brilliant. Okay, so hopefully we can set out in this part of the presentation what you can expect attending the inquest and who else can be there, and the different types of attendances that the coroner can seek. Now, as outlined on this slide, you can be invited to attend by a coroner, or you can be summoned. Now, it's more often, as has been set out earlier, that the coroner uses his or her Section 5 powers to invite a witness to attend. The coroner will be aware that if they invite a healthcare professional to attend, that witness should attend, and they shouldn't need to resort to summon a witness. As to your attendance, you can attend as a witness of fact. You may then be given what's known as interested person status. And now this is defined by Section 47, Subsection 2 of the Coroners and Justice Act 2009. That outlines the definition of an interested person as someone having a stake, not just being curious in the case, and the immediate obvious party to that is the family of the deceased. They are always given interested person status, and the further examples are given in the slide. Importantly, for all those watching, interested person status can be given to someone who may, by any act or omission, caused or contributed to the death of the deceased, or whose employee or agent may have done so. Now, that's quite widely interpreted by the coroner, and often we find interested person status being given very widely, and I'll talk a little bit more about that in due course. We may move on to the next slide. So this identifies who else can be present in an inquest, and again, this can be very wide if the inquest warrants it, or it can be very small. An inquest is held in public, so as you see there, members of the press and the public can attend. Whether or not press attend really depends on the nature of the inquiry being made. Some matters can naturally give rise to what the media considers to be a public interest. Sometimes the fact pattern itself amounts to what could be a reportable story, or indeed the person involved, be it the deceased or their family. In addition, you can have present representatives for all those involved, be it the hospital, be it the surgery, be it the CMHT, the police, the GMC can and are sometimes interested parties to the case. I've been on a couple of cases where that's been the case. And finally, you can have the jury if a jury is required, and there are certain circumstances where that is, and we'll go on to that next. Now, a jury can be between 7 and 11 people under the Emergency COVID Act. That has relaxed somewhat, so it's now the coroner's discretion as to how many juries can sit safely, and so whilst it doesn't have to be 11 and it can't be more than 7, the coroner could easily sit 8 if they felt that was a safe number to proceed with. At the moment, not many jury trials, jury inquests are being held, but it's likely that that will relax and go on. But when juries are required, there are specific circumstances under the legislation where that is required, and they're outlined on the slide. Death in custody, as has been previously explained by Jerard, can be widely considered. Custody has a very wide definition, can include immigration removal, police custody, in the custody suite, in the area just outside the custody suite, in the back of a police car, when you're detained in the street. So it can be very widely considered. Likewise, under the Mental Health Act, whether you're detained under the Mental Health Act or indeed you're a voluntary patient, that has been considered, and there's case law on that point. So it can be very widely applied. A jury can also be imposed where the coroner feels the circumstances of the death are such that the obligation on the state under Article 2 of the Human Rights Act is triggered. Now, that obligation, put simply, is the state's obligation to keep you alive. And so if I am detained by the state in whatever manner, be it custody, detention under immigration removal or the Mental Health Act, the state has an obligation to preserve my life. And if I die during those circumstances, the coroner is obliged to investigate that and investigate that widely. And that is often occasions where juries are impaneled. In terms of the jury's conclusion, the circumstances are that the coroner will direct the jury to return a yes or no answer to various questions that encompass the circumstances of death, and that will then result in their verdict. The verdict is permitted in certain circumstances. Now, in terms of when representation is required, it's often the case that the family aren't represented. Getting public funding for an inquest is quite difficult, so legal aid is quite difficult. The cost then falls privately to, but there are certain circumstances where the family can obtain representation, and we'll talk a little bit more about that later when we discuss claims. Where you should consider representation is if you're aware other parties in the case are represented. So under a principle of equality of arms, you might consider, well, if the trust are represented, the trust aren't assisting me anymore, is it appropriate that I have representation? Has the coroner already indicated that I'm under some form of criticism? Are the family upset with the care that was provided? And is it then appropriate to have representation? And again, you'll take the lead in part from the coroner. If they've given you as a witness interested person status, it would be appropriate to try and ascertain why that is, and then why, whether or not rather representation is appropriate. It doesn't immediately mandate representation, but it should certainly serve as a reason to pause and consider whether it's necessary, as criticism may be forthcoming. So it might be appropriate for your representative, be it a solicitor or a barrister, to assert your position in the inquest as best they can, and perhaps ask any relevant questions of anybody else involved, so as to clarify their evidence and position accordingly. One important aspect of being an interested person is that you're entitled to disclosure. So during the course of the coroner's investigation, they will collate various bits of evidence, statements, medical records and the like that will assist them in determining their inquiry, and that then forms disclosure. And it may well be that having been provided with that information, you can see why interested person status is given to you, because, for example, there's a letter from the family that expresses concerns as to the care that was provided. So it's on that basis that you might want to consider, well, if the family are represented and their representative is perhaps going to try and exploit some of those criticisms when I'm giving my evidence, I might want to have representatives there to assist me. And in respect of any GP members watching, that is something that you might wish to discuss with your MDU medical legal advisor.
You know, on that point, Helen, I think what I always say to my members when I'm looking at their reports is, you know, once we've finalised what we want to submit, pointing out that it's a dynamic process and that the coroner may not come to consider all of the information that's presented to them to quite late. When they're requested to attend the inquest, that they get back in contact with me as their advisor, so we can reassess where we are and if anything's moved on, if there's been any new developments, any complaints or intimation of claims, anything like that that may have changed the risks that might to that member, so we can then consider whether or not we need to instruct solicitors at that point.
Yeah, absolutely, because it's right to say, and it was briefly discussed earlier, that there is frequently quite a long delay at the point that you're being asked to draft a statement and prepare a report for the coroner to the inquest actually taking place. And during that time, there is obviously an opportunity for things to change. For the coroner, for example, to instruct an expert witness who has a view on the care, and that, if provided, could change your approach to things, and indeed the advice that we at the MDU team would give you. So here we have a fairly typical image of a coroner's court. They don't all look like that, but this is a fairly typical view. You can see, working from the far left of the picture going forward, we've got the public gallery. We've got 2 rows of table seats, and that's generally where the family and the representatives of any of the interested parties will sit. And then got the jury box to the top left, and then the raised bar where the coroner sits. And to the far right, we have the witness chair. And so you can see there that everyone is seated, unlike other court jurisdictions and what you might see on TV. An inquest is a seated approach. It lends itself then to an inquisitorial process rather than an adversarial approach. If barristers attend, they're not in gowns and wigs like they are in the Crown Court. That perhaps moves us quite nicely on to the approach you should take when attending the inquest. It's worth bearing in mind at the hearing that some families regard the inquest as an extension to the funeral, and you should therefore be sensitive to their grief. And a coroner will offer breaks as appropriate, and it is likely to just take up a little bit more time if the family are particularly upset. And that's often made more difficult perhaps if they don't have the benefit of representation, because then they have to do a bit of a work of a lawyer themselves, and that makes it a lot harder for them if they're particularly upset at the process. What it can also mean is the family not necessarily appreciating the purpose of an inquest. An inquest is inquisitorial rather than adversarial. So particularly when the family aren't represented, rather, the coroner will undertake most of the questioning of witnesses for their own benefit and then on behalf, in some ways, of the family. Often I find coroners will act as a bit of a mediator and interpreter for the family. So having or trying their best to understand the family's concerns, or then ask that witness questions for the family rather than having to do it themselves. Certainly, if they're represented, the coroner won't take that role, but you should be prepared both to be questioned, potentially by the family directly or the coroner on their behalf. In terms of attending, as we outlined earlier, a coroner can issue a witness summons, or they can invite a witness to attend under Schedule 5. Failing to attend an inquest can result in prosecution. I have known of it, not for healthcare professionals. What a coroner is more inclined to do in that case is actually refer that person to their regulator. That is a far more common approach. So it's certainly not something that you want to take the risk of. In terms of what you wear, it's a formal occasion, it is a courtroom, and you should feel professional and comfortable. I think if you are someone perhaps that always fiddles with a tie when they wear one, then perhaps consider whether or not you want to wear one. It's not automatically wear a suit, but wear something that's formal but that you are comfortable in. You'll naturally possibly be nervous, and the coroner won't hold that against you, but if you fiddle with your various parts of your outfit, if you're not comfortable in it, you might wish to try and find a happy compromise between those two. Now, as to the other elements here, obviously turning up is acutely important. If there's confusion as to the time or the venue, some coroners' courts have more than one courtroom venue available to them, so they are different addresses. Always try and seek clarity from the coroner's court, and I know that isn't always an easy task, but if in doubt, ask. And if, for instance, you then end up at the wrong court because you've been told to go to the wrong court, the coroner will not be too concerned with that. As to your giving evidence, it is nerve-wracking. The coroner won't hold that against you. Understandable that speaking and giving evidence about your own involvement can be difficult. The coroner will not expect you to appear as a professional, perfect witness, but it is important to give your evidence as clearly as possible and answer the question that's being asked. People will be taking notes, the more lawyers in the room, the more note taking will happen. If what you're talking about is particularly complex, the coroner might want you to take your evidence very slowly so that they can understand it. They might also seek to ask you various further explanatory questions as to that. That might not necessarily be for their behalf, it might be for the family. And again, that's particularly true where the family aren't represented. So if you're in an opportunity to see that the coroner is making notes or is typing notes on his laptop, if they've then looked up, you might wish to take cue from that you can then carry on and give the rest of your answers. And it's also important to remember to answer the question that you've been asked and answer that. And if the coroner wants to know more about that, they'll ask you questions. And likewise, if any of the other interested parties involved want to ask you more about that topic, they can do. You don't need to start an answer and then continue to talk. You can simply answer the question that's asked of you and then wait for the next one. And you don't need to feel concerned that you've given a rather short answer to a question, because it may simply warrant a short answer. The coroner will seek clarity where required, remembering there that you're there to assist the coroner, you're the coroner, and if they want more information from you, they'll simply ask. So if we could move on to the next slide.
Just one thing I was going to say very quickly, Helen, was that one of the problems we have as doctors is that, like I'm doing now, we like the sound of our own voices, and we've had exams where we're expected to speak to examiners and explain things clearly, and a hearing and your witness evidence is not a chance for you to keep on talking. Once you've spoken, once you've said your piece, you stop talking. So it's dress up, turn up, stand up, look up, speak up, and then probably rather cheekily shut up. So once you've said a bit, you don't say anything more.
Yes.
Helen, can I come in with a question as well, which is really important one, I think, raised by one of our members, which is they've said is, look, what happens if the doctor's concerned that they may face sort of criminal liability, and how does that sort of interface with a coroner's inquest and giving evidence?
Okay, well, there's a few aspects involved there. The coroner, when they reach their conclusion, as Jerard outlined at the start, they're specifically prohibited from apportioning any civil or criminal blame upon a witness in their conclusion. They simply cannot do it. They've got to be neutral when they reach their conclusion. They also have a power to refer a case to the police if they feel it's appropriate. And so if we have got to the point of an inquest being listed and we're all attending, we can assume that the coroner has considered the option to refer to the police and has declined to do so. Further, and we'll get on to it perhaps a bit later, but I'll deal with it now because it's raised. The coroner has a specific power, and indeed it's more an obligation, to warn a witness if there is the potential for the answer that they are giving in response to a question could incriminate them. And that warning is similar, in fact, to a warning that police give, where the coroner will invite that witness not to answer that question if they so choose. Now, I think if you are involved in a case where you feel you are potentially exposed to serious adverse consequences, such as a criminal investigation, then that is a case where getting the MDU involved at the outset is really key. Because from my perspective as a solicitor, if I thought that was a realistic option or indeed a risk, I would be bearing that in mind in every single communication I have with the coroner, and even from writing a statement, I would want to have real control over that content so I can protect the member from that from the outset. And if need be, get some specialist advice from a barrister who has additional criminal experience.
Great, thank you, Helen. I'll let you carry on.
How to approach a hearing. Read your own medical report, and several times is appropriately added there. I can't stress enough how important it is to be aware of what you've said, and this is particularly important because of the inevitable delay that arises between writing your statement and an inquest. And some courts regrettably are operating with the delays of a couple of years, and given the environment that we've all been enduring over the last couple of months, that delay across the country is likely to get worse. So read your statement, read the patient's note, mark it up, flag it up, highlight it, read any other aspects of the case that are particularly relevant to you. If, for instance, there's a critical RCA, if the family are critical of you, if there's an expert report that raises questions as to the approach you took, read that and be live to it. That's not to say, of course, that you can't refresh your memory during the course of the inquest. For larger cases, there is often a witness bundle prepared, and so the coroner is likely to start your evidence by saying, Doctor, you provided me a statement on X date. You can find it in the bundle at page 24. Please now turn to it. And you've got your statement there, and the medical records will also be there, and you can acquaint yourself with those. And it's perfectly appropriate to say, if I may just check the note. That's absolutely possible. The coroner will expect you to have a good knowledge of them, but not a photographic memory. And so if in doubt, check the notes. And if you're not sure of a position, then say, I think it's this, but if I may, just check the notes. The coroner will have no difficulties with that, and they will give you a short time to do that, and then you're able to answer the question. So it's really, really important to familiarise yourself with the relevant aspects of the case. Equally, if a question is asked of you and you do not feel you're in the best position to answer it, then explain that. It's not an exercise in memory, it's not a test. If in fact that question is better asked of another healthcare professional involved in the case, then say that. And the coroner is there to get information from you that's accurate and honest and of assistance. As such, if that information can be better provided by somebody else, the coroner will gladly take that note. Similarly, if the coroner is inviting you to give expert evidence and you're not there in a capacity as an expert, then you are able to decline to answer that. You are able to say that the answer to that question goes outside your scope of practice. As difficult as it may feel at the time, try not to let the coroner force you into a corner of answering a question that you can't confidently stand by at any point in the future. Similarly, if you sense that your professional conduct or competence is called into question, you should feel empowered, and I know that's easy for me to say as a solicitor, but you should feel empowered to ask for an adjournment of the inquest so that you can contact the MDU or Trust Legal and ask for advice. It's unusual, but it does happen, and indeed there are occasions when the coroner or when the other party seeks to pause an inquest because an issue like that has arisen. So if in doubt, raise it, and the coroner can give you some further thoughts on that. Similarly, oh, sorry, I just paused for a water. Similarly, if you are questioned in a manner that suggests you've committed a criminal offence, and this is what I touched on earlier in response to that question, you may be advised by the coroner to decline to answer, and that is a positive obligation on the coroner to give a witness that warning before the question is answered. Now, I would hope the coroner would have reviewed the case sufficiently so as that is unlikely to occur, but it's something to bear in mind. And I would say categorically, if a coroner gives you such a warning, do not answer the question and ask for the hearing to be adjourned so that you can get representation. And finally, if you are taking confidential notes to court, and taking the medical records is a good approach. A hearing bundle for larger cases should always be provided, but court resources are not what they should be, and sometimes it doesn't occur. And so if you are going to be relying on medical records, take them with you, but obviously keep them safe, both when you're at court and when you're travelling to and from court. Now, in terms of the inquest process itself, you may be questioned by the coroner. You are there to assist them with their inquiries, to assist them with answering those 4 questions of who, when and where and how the deceased came by their death. You can also be available to be questioned by the representative of any of the interested parties, or the parties themselves if they don't have representation. And so the family can question you, or the coroner can assist a family with those questions. The representative from the trust, the MHT, the police, any of the interested parties can ask you questions. The jury can also ask witnesses questions, albeit that is the process for that is the jury raises a question and it's put first to the coroner, who may or may not take submissions from the interested parties involved, and then the question will either be put as it is, or indeed rephrased if it's perhaps worded in a way that doesn't assist the jury with their consideration. And finally, your own representative can ask you questions. That's always done at the end of a witness giving evidence, and it's quite an advantageous position in some ways, because it allows me as your representative to sweep up and ask any final points of clarity if I think an area has been explored but not necessarily understood by one or other of the parties, and really I'm focusing on the coroner there, then I can ask some supplementary questions just to make sure that that particular aspect of the case has been fully understood. The coroner should seek to intervene and exclude any appropriate question. The example given there is absolutely correct. This is particularly important where the family aren't represented. They won't appreciate the parameters that an inquest has to be conducted in. They won't appreciate what is a relevant question to the coroner, and it is the coroner's view that is paramount here. They might want to ask a question, they might want to know a certain point, but if the coroner doesn't feel it falls within those 4 questions, how, when and where, then it's not relevant. Now, certainly for an unrepresented family, we advise members to be empathetic to their position, because they simply won't understand what is relevant or not, and they won't necessarily be rational as to their approach, but it comes to a point where inappropriate questions, particularly those that are pointed to matters of liability outside of the inquest, then they have to be objected to, and the coroner will then make a ruling on that question. Now, this is a particularly important point. The coroner will ask a question, and they may ask that question because they don't know the answer. They may ask that question because they do know the answer, but they want the answer put in public, in the public record. It's a public hearing. They are obliged to ensure that anyone sitting at the back understands the circumstances of the case and the reasons the coroner has reached in term their conclusion. And so if a somewhat obscure question is asked, answer it as best you can, and don't think about why the question is being asked. It's really important to answer the question asked, not the one you would prefer, or that was asked previously, or that you think will be asked next, or indeed that which you think ought to be asked next. It's particularly important, again, for the benefit really of the family, that your answers are as clear and free of jargon as possible. And if a coroner is breaking down your response in a very segmented, simplified manner, it may A, be because they don't understand, or B, it's because they think some of the other parties involved don't understand. So as frustrating as it might be, it's important to remain professional through that process. The coroner's getting to the bottom of things, and assisting them with their inquiry is your obligation. So just have that in mind. Secondly, second guessing a coroner will be given short shrift, and they are likely to snap when they think a witness is potentially being evasive in answering a question. Bear that in mind. Answer that which is asked. It brings us quite beautifully onto our next point. It's really important to remain polite and professional and formal. You are there as a professional witness, whether it's an expert witness or a witness of fact. You're a professional regulated person, and the coroner will expect you to give your evidence in such a manner. That's not to say they're expecting perfect prose. They aren't by any means, and if you're nervous when you're giving your evidence, the coroner will disregard that. It will not be held against you in any way. It's an unfortunate part of your job, but it's not part of a job that you're necessarily trained for. So the coroner will not hold that against you. So don't let that worry you as far as you can. It's really important to make sure you've understood the question before you answer it, because if you haven't, what you then say isn't accurate, and you risk a conclusion that you're perhaps inconsistent with your answers. And so if in doubt, ask, sir, madam, may I just clarify, are you asking this? And the coroner will say yes, in which case you can answer it, or no, what I want to know, doctor, is this. And they might even explain a bit more as to what they're thinking, and that will allow you to understand. It is really, really important you understand the question. Similarly, taking your time before you answer, thinking about what you're going to say, checking the notes if you're unsure, and you can buy yourself a few seconds by saying, madam, may I just check the notes? May I just check my statement? The coroner will not take an issue with that. Likewise, and this is more going to be the scenario for when representatives or possibly the family are asking you questions. You're there to provide evidence of facts. You're a factual witness to assist the coroner. You're not there to speculate. You're not there to hypothesize. And so if such a question is posed to you, the best approach is saying, in this case, this happened. And that's that. I'm not in a position to speculate. It wouldn't be appropriate for me to speculate, and so I can give you what happened. Otherwise, I'm not sure I can assist, and you can be quite firm there. And finally, direct your answer to the coroner. They're taking notes, as we've explained, and it's really important that they understand what you are saying, because it's their opinion that then forms the conclusion. So if you consider your competence or conduct is called into question, as I've said, you can ask for an adjournment, and you should then seek immediate advice. Similarly, if you're given that warning, or you get the impression that you're being criticised for something akin to a criminal offence, decline to answer. And as I said earlier, if you anticipate that is a possibility, even remote, please do get in touch, because we can manage that from the outset. So on to the bit we all are waiting for, the conclusion. It used to be known as a verdict, is now known as a conclusion. The list we have here on the slide are known as short form conclusions. 1 or 2 words encapsulate the circumstances of death. However, there may be a narrative conclusion. What narrative conclusion is a bit more information, a paragraph, a couple of sentences summarising the circumstances leading to death that may or may not include some criticism or concern about future public safety. Now, Chief Coroner has issued guidance to coroners that they should wear all possible short form conclusions. The list we have above is not a complete list, but it's the, I'd say, most used short form conclusions. But where a coroner feels a short form conclusion wouldn't encapsulate the proper circumstances and facts of death as they have found, then they can use a narrative, and they are becoming increasingly used. Now, how does a coroner reach a conclusion, be it a narrative or a short form? They apply what's known as a standard of proof, which for nearly all conclusions in a coroner's court is based on the balance of probabilities. So is it more likely than not that the deceased committed suicide? The only exception to that is unlawful killing, which requires a criminal standard of proof, so beyond all reasonable doubt. A further sting in the coroner's armoury when it comes to their conclusion is adding a rider of neglect, namely that the conclusion, be it narrative or short form, was contributed to by neglect. Now, this has been debated and then defined by various bits of case law, but in short, you can consider neglect to amount to a gross failure to provide adequate care to those in need of it. It has a very specific and narrow meaning in inquests, and it isn't the same as clinical negligence. An inquest verdict is not able to determine that, and so a neglect finding at the hands of a coroner does not necessarily mean that a negligence case would be commenced or indeed won as a result. So, following an inquest, what can arise? Having reached the conclusion, be it short form or narrative, with or without a neglect rider, the coroner can then issue a what's known as a prevention of future deaths report. The coroner, having concluded the case, if they are of the view that there remains live risks involved in the circumstances that could contribute to further death, they can issue a report, and that essentially outlines what they found, what their concerns are, and invites the recipient of that notice to respond, setting out their action plan. This may arise as an example where the death has occurred due to a surgical error and the coroner wants reassurance as to what steps the trust has taken to remedy the problem that caused or contributed to the death. Proactively anticipating such concerns might obviate the need for such a report, and that's something that both myself and Jerard and our colleagues always have an eye to. The GMC monitors issuing of prevention of future deaths report when they are published online, and it is often something we need to consider when we're considering whether or not the threshold for self-referral has been crossed. And it is potentially also something that a family may consider to assist them with a civil claim. So specifically, what does a prevention of future deaths report require? Often used example here is where, in response to a sepsis death, a trust has a policy in place, but that policy isn't followed, and sepsis is left to have a fatal cause. The coroner will want assurance from the trust during the course of the inquest that their sepsis protocol is in place and understood and followed by all those who work therein. And if the coroner hasn't been convinced of that during the course of the inquest, then they can issue such a report. The slight oddity with PFD reports is that the coroner is obliged to issue one, the recipient is obliged to respond, but you are not necessarily obliged to agree with the concerns therein, or indeed respond in any other way than saying, I've received your letter. In practice, you're all regulated professionals. You are obliged to respond to the coroner under the obligations the Jerard has set out with the GMC. And so assistance in that it should be sought at all costs. Where the coroner considers the duty to issue a prevention of future death report is live, but the threshold perhaps hasn't crossed, they can issue what's known as a paragraph 37 letter, which outlines their concerns to a relevant person or organisation. For example, the matter in question may not relate to a risk of future deaths per se, but it could nevertheless relate to a concern in the case. And in my experience, they are being increasingly by coroners.
Helen, I'm sorry to rush you, but I'm conscious that we're eating into lunchtime.
Final wrap-up slide. The DMC obligation under criminal offences and criticisms outlines that where you have received criticism that relates to serious matters that could call into question your fitness to practice by a person leading either a formal inquiry, and that's further defined at paragraph subsection 8E, a coroner's inquest. So any comments made in the conclusion, be it narrative conclusion, a neglect rider, or indeed a prevention of future death report or paragraph 37 letter, we need to consider that carefully so as to work out whether the threshold for self-referral has been reached. Finally, a further upshot of an inquest can involve a claim for negligence. Families often use inquests as an information gathering exercise to assist them as to whether or not to launch a claim. Representation is often provided on that basis in anticipation of costs being recouped in a certain claim. And so you need to be live to that possibility. Likewise, hearings are public, the press may attend a report, and there are various aspects therein as to the confidentiality. Press office, both at your employer or indeed the MDU, can assist. But it's really important to bear in mind, if the press are there, you and on behalf of your organisation want to come off well, and so you need to bear that in mind.
Okay, Helen, thank you very much. I'm going to try and wrap this up now. I realise that we've been giving a lot of information. Ed, please interject if there's anything that you feel we need to answer. Specifically in this case, this member opened a case file, was assisted by a medical legal advisor, and we instructed one of our solicitors like Helen to assist with it because the RCA was critical. The root cause analysis was so critical, we felt it was appropriate to instruct a barrister to represent the member's interests in court. It's that equality of arms issue when the trust have instructed a barrister. The member indicated in retrospect he might have discussed the patient with a more senior colleague, he was quite junior, and considered doing a scan. And interestingly enough, as is often the way, the family were not specifically critical of the member, but focused instead on other members of the team, in this case, the nursing staff. The conclusion in this particular inquest was one of natural causes with a rider of neglect. So coming on to the summary. Coroners' investigations can be complicated and stressful. So if you're asked to be involved in one, do ask for help. A good report, and we can help you with that, may avoid you being called in person to give evidence. Although the coroner is not seeking to apportion blame, other investigations can follow, including the GMC and potentially claims and negligence. It's important, as in any report written as a doctor, that you're open and honest in anything you produce, And it's important also, I think, that you demonstrate that lessons that are there to be learned from that case have been learned. Ed, do you have any questions that have come in that we need to address?
I think I'm just conscious that we're really over time and people are very busy. So I think we've tackled most of the ones that have arisen. We've talked about the needs for representation. Sure. And so I think we've tackled most of the interesting topics that have come up, Jerard.
All right, thank you very much. And Helen, thank you very much. And thank you everybody for joining us during your busy day. We know you've got lots to be doing and lunch to take too, if you're lucky enough to get that. So thanks very much. Do remember to ask us any questions about your care of patients, anything to do with coroner's investigations or medical legal issues. If you're a member, do write into us. We're here to do our best to help you. Have a nice day, everybody.
Thank you.